a two-judge bench of the Supreme Court of India ruled that Muslim women in India are entitled to maintenance to be received from their husband after divorce under Section 125 of the Criminal Procedure Code, or the CRPC. This is a resounding victory to decades of silent battle faced by Muslim women.
I completely agree, Sandhya, on this. So what began sometime in 1985 in the Shah Bano Begum case, it has culminated in 2024. What a long battle, right?
True.
And with the judgment in Mohammed Abdul Samad versus the state of Telangana case, actually, that is. And now it is also important for us at this point to understand the chronology of the events, how it has taken place with the Shah Bano case which has come up. So it is one of the most celebrated cases in the Indian judicial history. Here, if you look into, Shah Banu actually married her husband, a lawyer, in 1932, and she had about 5 children. And suddenly, if you look into, she was disowned by her husband in 1975, almost after 42 years of being married, with absolutely no financial support. And then she had approached the court seeking for maintenance from the husband.
Right.
Now, in the magistrate court, what has happened is they granted a partly sum of rupees, those days about a minimum of 25 rupees as maintenance.
Yeah, the judgments are not, they did not factor inflation at all.
Correct. 25 rupees. Where do we go? And then she approached the High Court of Madhya Pradesh, where the High Court increased the sum to about 179 rupees. Okay. And later on, her husband appealed in the Supreme Court. And the Supreme Court actually ruled in favor of granting the maintenance to Shah Banu.
Right.
Here, if you look into, the court also held that the provisions of Section 125 of the CRPC relating to the maintenance of the wife shall be uniformly applicable to all citizens of the country, irrespective of their religion. I think this is one of the most important aspects when it comes to maintainability for women if they are divorced, right?
Right.
And this judgment caused so much of religious displeasure and political backlash those days. And, therefore, to negate the effect of this judgment, the government then enacted the Muslim Women Protection of Rights on Divorce Act way up in 1986.
Right. Immediately after the Shah Banu judgment. Yes.
Correct. Now, this act also clearly stated that Muslim women are entitled to alimony only under this Muslim personal law, namely this 1986 Act, be it whether it is their meher, which they call as money, or the dower, or the maintenance money that the woman is entitled under the iddat period. Now, the iddat period is nothing but typically 3 months after the divorce, when the women are not supposed to remarry.
Right. Actually, correct that you mentioned this Muslim Women Protection of Rights Act, because ironically, the act is called the Shah Banu Act, because it came right after the Shah Banu judgment was passed. It didn't make sense, because why it was called the Shah Banu Act? Because the judgment in the Shah Banu case was negated, right? Saying that Muslim women are only entitled to maintenance as per the Muslim personal law.
Correct.
Right?
Correct. Absolutely. True. So this is also because that in Muslim personal law, if you look into, marriage is considered only as a contract and not as a sacrament.
Right. Subathra, in 2001, Daniel Latifi, the lawyer who represented Shah Banu in her case, filed a writ petition in the Supreme Court on 2 counts, stating that the Muslim Women's Protection of Rights on Divorce Act of 1986 was unconstitutional, as you could not deny maintenance to a woman who is not financially independent, and a woman who is not financially independent may continue to be so even after marriage, and hence. By not granting maintenance or alimony to her, this would be violative of her fundamental rights under the Indian Constitution. Okay.
Right.
Now, in 2001, the Supreme Court ruled that a Muslim husband is liable, or it's his responsibility to make reasonable and fair provision of maintenance or alimony to a divorced wife. Okay, and such reasonable and fair amount will extend way beyond the iddat period of 3 months that you were just mentioning initially. While stating that, but the apex court also held that the Muslim Women's Rights Act 1986 is very much constitutional and very much valid.
Correct. So through this kind of judgment, the Supreme Court also struck, a delicate balance between ensuring there is some kind of gender justice while also not letting judiciary to interfere too much into the personal law or in the religious aspects.
Right. Over the years, there have been various conflicting judgments. Various high courts have been giving out judgments which are, contradicting one another until this year. And on 10th July 2024, when the apex court passed this landmark judgment in the Muhammad Abdul Samad versus the state of Telangana case. If we had to look at a brief about the case, Abdul Samad divorced his wife. His wife approached the trial court seeking maintenance under Section 125 of the CRPC. The trial court granted 20,000 rupees per month as maintenance or alimony to Samad's wife. Aggrieved by this, Samad approached the High Court. Okay, the High Court reduced the maintenance or alimony from 20,000 rupees to 10,000 rupees per month, but maintained that even a Muslim woman is entitled to maintenance under Section 125 of the CRPC. Again, aggrieved by this judgment, Samad has actually approached the Supreme Court, stating that when there is a Muslim law, that is the Muslim Women Protection of Rights of Divorce 1986 Act, a Muslim personal law is there, that will take precedence or have an overriding effect over CRPC, which is a general law. That was his main contention.
So, Sandhya, if you look into this voluminous judgment, like it is about 99 pages, both the judges gave varying reasons, but a same kind of judgment.
Right.
So, if you look into Justice Augustine George, dwelled into the legal interpretation of the laws, whereas Justice B.V. Nagaratna actually gave the gender perspective, stating that very clearly, alimony or the maintenance must not be just given to women as a charity, but it is given with the intention of safeguarding women, especially who are financially dependent.
Right. This part will resonate with women across religions and across nations and the world.
Absolutely. Yes. So both the judges also arrived at a common conclusion where it states clearly, Section 125 of the CRPC applies to all married women, including Muslim married women, plus Section 125 also of the CRPC applies to non-Muslim divorced women as well. So both, so immaterial of the religion, any divorced woman will fall under this category.
Right. Subhadra, the judgment also expressly states that as far as Muslim divorced women are concerned, Section 125 of the CRPC will apply to Muslim married women. If the Muslim married women are married under the Special Marriage Act, even then the Section 125 CRPC will apply. If they are married under the Muslim personal law, even then the Section 125 of the CRPC will apply. This is because this CRPC remedy is in addition to the remedy available under the Muslim personal law. So, simply put, a Muslim divorced woman can seek remedy either under the Muslim personal law, which is the 1986 Act, or under Section 125 of the CRPC, or both. The remedy is open to her for both. Yeah. So.
Yeah. So if you look at it, this is because of the personal laws are not in derogation, but in additional to the CRPC, right? So here, if the husband contests for such kind of a maintenance, then it is upon him to prove two important aspects. One is he has to fulfill his obligation towards the maintenance under the personal law. And the second one is also the maintenance which has to be provided by him to his divorced wife. It has to be sufficient for beyond the idat period. So these two are the important aspects.
He has to prove this.
Yeah. And Sandhya, this judgment is also truly an epic judgment, as it does not, distinguish women based on their religion. Very important thing.
Yes.
And also, while promoting gender justice, it also continues to maintain the balance by giving the personal law its due,
Right.
So we hope our viewers have enjoyed this episode and this landmark judgment given by the Supreme Court. So thank you once again for watching. Until then, bye-bye.
Bye.